Good afternoon. My name is David Gallo. I'm the director of the AIFC Academy of Law, and welcome to all of you from across the globe who have joined us today. We're broadcasting from Nur Sultan, Kazakhstan. We're very pleased that you have joined us. We hope you're all staying safe and you're staying productive in your respective jobs and moving your law firms forward. Thanks so much for joining us. We have a very exciting lecture today, delivered by a couple of world-class legal specialists in the area of employment law and HR practice. My friend and colleague, Dr. Alexander, Professor Van de Putte, is going to formally introduce the speakers. Well, Professor Van de Putte is the chairman of the AIFC Academic Council of the Academy of Law. He's also the Chief Strategy Officer and the Chairman of Corporate Governance and Stewardship at the AIFC at IE Business School, one of Europe's leading business schools. Professor Van de Putte is a lecturer and professor of strategy and strategic foresight. So with that, Alexander, please.
David, good afternoon, and good afternoon to everybody. Thank you very much for the introduction. I have indeed the pleasure to introduce the topic of today, but also our two speakers. So the topic is, as you all know, it's employment and HR, AIFC employment laws and modern international employment arrangements. As an international financial center, we obviously have to cater for both expats and international organizations. And therefore, international employment law is going to be critical for us to move forward. And today's agenda, there are three high-level, broad issues that the speakers will delve into in more detail. First of all is a high-level summary of the key aspects of the AIFC employment law. That's number one. Number two is, well, with the recent pandemic, there needs to be a focus on COVID-19 and HR, and more specifically, the next stage of employment relationships as we emerge from the global pandemic. And then finally, international mobility, how to properly employ and engage a truly international workforce. So those are the three areas that our esteemed speakers will be talking about, and let me now introduce them. First is Mr. Luke Tapp. He is the partner and head of the Middle East employment practice with Pinsent Masons, LLP. He is based in the Middle East, I believe in the UAE, and he advises clients based in the UAE and the broader Gulf region on all aspects of employment and labor law issues. He will be joined by his colleague, Michael Chattel, who is a solicitor at Pinsent Masons as well. And I believe that Michael is based in London, joining us from London. So, and he works very closely with Luke on advising clients on all aspects of employment law matters. And I hand over to Luke, who has also set up a presentation. Please do enjoy on this, the discussion on this very important matter. Luke, over to you.
Thank you, Professor Van de Putte, and thank you, David, for the introduction and welcoming us to deliver today's presentation and today's training session. We're delighted to be here. We're really excited to talk to you about the AIFC employment laws. As Professor Van de Putte said, this is our specialism. It is what we advise clients on a day-to-day basis on international employment laws, and the types of laws, the types of provisions that we see in the AIFC in terms of the new employment regulations are something that are really interesting to us and something that we've been advising clients on over the past 6 to 12 months. So in terms of today's session, well, thank you very much for so many of you joining us today. We're conscious there's a lot of HR directors joining us for today's session, a lot of in-house lawyers, a lot of employment specialists, which is excellent. We always wondered, when we would become popular within our organizations, within the market. It turns out that it just took a global pandemic for everybody to want to speak to HR, for everybody to want to speak to the employment lawyers. So we know you've been extremely busy over the past few months. So we really value you coming and spending an hour with us today to go through these materials. We think now is a really good time to be talking about the employment legislation because, of course, organisations have had a chance to reflect on the impact that COVID-19 has had on their global workforce, also their local workforce in Kazakhstan as well. And it's a good time to look at the law, look at what the law requires us to do as employers, and try to find the right way forward in terms of balancing that regulatory requirements, but also shaping your workforce for what the economy will look like going forwards. Just a little bit about Pinsent Masons. I won't spend too long on this slide. We're an international law firm. We're one of the largest law firms in the world. Our head office is in London, but we have offices all over the globe other than in the Americas. So we're not in North America, we're not in South America. In terms of our employment practice, that's an important part of Pinsent Masons. Again, one of the largest international employment practices in the world. So we have partners that specialize in employment all over the world, and we advise international clients on all of those local laws as well. In terms of today's agenda, as Professor van der Put said, we're going to cover off three key topics really. Key employment documentation, and part of that is about mobility, it's about recruiting an international workforce. We'll talk about secondments within that section as well, and international mobility. We'll then talk about some key aspects of the AIFC Employment Law, the types of areas where we see clients getting into a bit of difficulty. So it's really important for you to be aware of what the regulations say in relation to these particular provisions that we've picked out to discuss today. And then finally, we'll talk about COVID-19, the impact on HR, and kind of the next stage for global employment relationships and global workforces. So that's the agenda. I think one of our colleagues, Almas, will be in touch with you on the chat, may have already messaged you. We're really keen to make it interactive during today's session, and I'm more than happy to field questions as they come to you. And of course, it sometimes helps the other delegates for me to raise those questions, you know, while we're talking about a particular topic so they understand the context of the question. So as we're talking through the slides, feel free to send in a question via the chat. And as they come through, we'll answer as many as we can to make it as interactive as possible. So to begin with, key employment documentation. I think this is a really good place for us to start because it's about the platform of the employment relationship and what's really important in terms of how we structure that employment documentation when we're recruiting somebody. And really, you know, in the AIFC, the offer letter is the starting point. And it's really important that employers think about the offer letter, because what we see international clients doing a lot with offer letters is getting themselves into difficulty, exposing themselves legally. And it would be the same in the AIFC, because what a lot of managers will not appreciate is that when we send out an offer letter, that's likely to create a binding promise or a binding contract to an individual. And if at some point in the future we're unable to follow through with the offer of employment by withdrawing from the offer letter, it could create a breach of contract. So, you know, we had a really sort of typical situation that arose a few months ago for one of our clients, where a manager had interviewed somebody, they liked them, they just sent out an email to that individual and just said, you know, we'd really like you to join us, we're going to pay you X amount of salary per month, and we'd like you to join us on the 1st of March. Obviously, then there was COVID-19 began to be an issue, and so the client had to review what it wanted to do in terms of recruitment, and it ultimately had to stop that recruitment. It couldn't go through in the offer of employment to the individual. So it unilaterally withdrew the offer of employment to that individual, and that was a breach of contract, because the commitment the company had made to the individual in an email was that you would start on the 1st of March and you would start on a particular salary, and there were no conditions around that. So it's very easy for companies to create some legal exposure to themselves where they're giving out offer letters without actually doing a proper legal analysis of the impact of that offer letter. So what we recommend to clients, to GCs, to HR directors, to lawyers, is to advise the business to think about the offer letter, to have a template offer letter, and to say to the commercial managers, we don't make an offer of employment. We don't offer a salary. We don't offer a start date to anybody unless it's in compliance with this template, which you need to complete. And the template needs to set out the conditions of employment. So it could still say, we want you to start on the 1st of March. We want you to work in X role. We want you to be paid this salary. This is the offer of the salary. However, this is all subject to the following conditions. And the type of conditions that you might put in place would be things like completing reference checks. So as getting 2 referees from your most recent employer. It could be obtaining a visa to allow you to work if it's an expat that we're recruiting. It could be subject to you being clear to work for us. So for example, you don't have any restrictive covenants in your existing employment contract. But it's those types of conditions which it's extremely important go into that offer letter. So we just want to flag that for clients in the AIFC, that it's really important that you put those conditions in the offer letter and you just have something in place that protects you legally. Then moving on to the employment contract. Employment contracts in the AIFC are going to be really, really important because they're referred to in the legislation. They're binding on companies, of course, and a lot of the legislation actually in the AIFC refer to what it says in the employment, refers it back to the employment contract. So, you know, a couple of examples, Article 8 of the AIFC talks about when you're recruiting somebody, you know, companies cannot make false representations. And so it's really important that the employment contract sets out exactly what the offer of employment, the terms of employment, the position, the responsibilities are to deal with that Article 8 risk of an employee claiming that false representations were made later at a later date. The law also talks about the ability to make deductions from salary. Again, it says subject to that being agreed in the employment contract. So really important to have some good wording in the employment contract about the right to make deductions to salary. Terminations as well. AIFC legislation is it's quite unusual. It's quite unique insofar as the gross misconduct terminations for cause, and we'll talk about terminations later in today's session, but terminations for cause actually have within that provision the right for a company to set out what that could mean. So companies can include terminations for cause, definitions of terminations for cause within the employment contract. So an example might be you assault somebody in the office. You know, that's something which I'm sure you would consider to be a gross misconduct type offence. It's really important to define that in the employment contract, amongst all of the other reasons that would be a breach of your code of conduct. So that's why the employment contract is really important. It's also important to include provisions like confidentiality, so employees can't disclose confidential information, IP, of course, somewhere like the AIFC, a lot of professional service companies operating within that jurisdiction, really important that your IP is protected, and restrictive covenants. So if you want to have some protection against employees leaving your business and going and working for a competitor, really important to include restrictive covenants in there as well that are appropriate for the jurisdiction. So again, employment contracts, very important to think about and important to make sure they comply with the legislation. One question that I was asked to think about in advance of the session was in relation to what takes precedence. So if the law says one thing and the employment contract says another, what would the court find to be enforceable? And the answer to that is that the starting point is the law. So the law sets out the minimum standards of employment, and we'll talk about them when we go through the next section on key employment terms. But the law sets out the minimum terms of employment. If the employment contract goes below that, so an example, the law says you're entitled to 20 working days annual leave per year. If the employment contract says you're entitled to 15 days per year, then that's unlawful. It's a breach of the law. So the court would find that the 20 days is what's applicable to the employee. So the starting point is the law, but then if the employment contract provides something that's enhanced, that's over and above what the law says, then the court will find that to be binding on the company. So if the contract says you're entitled to 25 working days annual leave, then that's what's going to be binding on the company. So starting point is the law, and then the employment contract if it's enhanced. So that's just a quick canter through some of the employment documentation that we offer to candidates at the beginning. Moving on to the handbook, and I've got a slide on the handbook generally. So just a couple of important points to make. Contractual or non-contractual for the employment handbooks. We always strongly recommend that they are non-contractual. So within an employee handbook, you will have lots of different policies, and we've given some examples there on the slide of the types of policies you might want to include within a handbook, things like disciplinary policy, equality, non-discrimination, IT use. And of course, the primary objective of those policies is to have a best practice workforce, best practice approach to HR and employee engagement within the workforce. That's the starting point. But of course, from my perspective, from your employment lawyer's perspective, it helps us. It's going to be helpful if we get into a dispute, and certainly not unhelpful. We don't want your policies to make it more difficult for us if we're trying to defend a situation. And an example of where it was made unhelpful for us recently was in relation to a dispute that we were working on, where a client of ours had terminated somebody, ultimately because of poor performance, poor ability to generate financial commercial revenue for the business. So there's a clear justification for the dismissal, and they terminated with notice. What was unhelpful was that the dismissal policy had quite a convoluted disciplinary process that the client should comply with if it wanted to comply with its own policy. And that was over and above the requirements under the regulations, the provisions within the policy. So what the client had done is they'd complied with the regulations in terms of termination, but they had not complied with their own policy. So what the employee argued was that it was a breach of contract, because they said the disciplinary policy was contractual, and the failure to comply with the disciplinary policy was therefore a breach of contract. Helpfully, the client did have some wording in the handbook that said the status of the policy is non-contractual. So we leaned on that within the dispute, within the pleadings. We said it's not a contractual policy, therefore we didn't comply with it. It was a breach of policy, but it wasn't a breach of contract. And we were successful in that argument. But it could have been clearer, to be honest with you, within the policy. It could have been clearer. It could have been clearer in the employment contract that says the handbook is not a contractual term of this employment contract. The other advantage of having non-contractual is it means you can change the policy without getting agreement from the employees. So if you ever want to update a policy, you can do that without getting the consent of the employees, because it's not a change to the terms of contract. So non-contractual in nature and in status, and then in terms of the types of policies, those are the ones set out on the slides, and we will share a copy of these slides with you after the session. But that's just an example of some policies that we recommend clients in the AIFC think about implementing within their organisation to reflect best practice, to protect them under the law as well, and to make sure there's a good approach to HR that reflects best practice. And the final slide on this section is on secondments and transfers of employees. So it's becoming increasingly common for global workforces to move people around their different international offices. We certainly recommend that to clients, you know, in the AIFC and in the region, in Central Asia, as also as in the Middle East, that clients move their employees around to give them international experience. Also at the moment, of course, with COVID-19 having such a significant impact in different parts of the world, and we're finding with some clients that they're having some countries where COVID-19, the country's getting over it and the economy's coming back, and they want to increase the manpower in that jurisdiction, whereas in other parts of their network, the economy is still suffering. So moving that manpower around the globe is something that's quite common at the moment, and it has been increasingly common with our clients over the past few years. These are just some items to think about when you are transferring or seconding staff around your network. I mean, the big one really is duplication of employment rights. So we had an energy client that we were assisting with a dispute a couple of years ago, and in relation to that client, they had an individual whose home country was Germany, actually. So that's where the person started their career with our client in Germany, worked in Germany for a few years, then moved to the region as a secondment to spend a couple of years in the region on secondment. And then a couple of years ago, the client had to make some redundancies, so made that individual redundant, and the individual brought a claim in both jurisdictions, in Germany and in their local jurisdiction. And because the two courts didn't talk to each other, there was no way of consolidating the claim. the client just had to defend the claim in both jurisdictions, defend it in Germany, defend it in the local jurisdiction. And of course, we supported them with it. And ultimately, we were successful on the majority of the case in both jurisdictions. But the client incurred legal costs. The client incurred risk in 2 jurisdictions because they hadn't tidied up the secondment paperwork. It would have been very easy to do that with a short secondment agreement that says, okay, while you're employed locally in the region, your German employment relationship is terminated, no longer exists, there's a break of service there, so you only have one set of employment rights accruing whilst you're on secondment. It's that type of terminology that we really require within the secondment agreement and the transfer letters that you need to think about. So again, it's just something to put onto your radar, and particularly at the moment when more people are moving locations in terms of where they're working within their organisations, to make sure the secondment documentation is as tight as it can be to avoid being subject to claims in more than one jurisdiction. So that was everything on employment documentation and sort of engagement and secondment. So moving on to the next section on key aspects of the AIFC employment law. So I have some provisions that I wanted to mention and bring to your attention today. And Michael, my colleague who's also on the line, will be talking to us about the anti-discrimination provisions within the AIFC employment law during this section as well. So to begin with, wanted to talk about annual leave, because annual leave is such a hot topic for our clients at the moment. So what we've seen with clients in Central Asia, clients in the region, is that during the period of COVID-19, when people have been stuck, unable to go on leave, working from home, working remotely, people have not been taking their annual leave. So there's this build-up of annual leave within the market. So it's really important that clients in the AIFC understand what the legislation says about the accrual of annual leave. So as you can see on the slide, it's very straightforward. 20 working days per year is what a person accrues. In terms of carry forward, employees are allowed to carry over 5 working days of accrued and untaken annual leave from one year into the following year. So it's a cap of 5 working days annual leave. Again, as I said earlier, if you want to enhance that, then of course companies may. So they, if somebody doesn't take any leave this year and they have 20 days at the end of the year, at your discretion as the employer, you can agree to carry forward more than 5 days. You can agree to carry forward to 20 days into the next year if you keep a record of it. But under the employment law, you must recognise at least 5. So you can't write off all 20. You'd have to at least allow 5 days to be carried forward. We had a dispute in relation to this type of issue recently as well, where a client hadn't been recognising the ability of employees to carry forward their annual leave, and the individual raised a complaint and said, last year I had 10 days that I had accrued that I hadn't taken, and you didn't recognise any of them in 2020. So I've lost them, so I should be paid in lieu of them. And that didn't go to the courts, but it was a dispute that the client had to consider internally. And our advice to them was, yeah, absolutely, we've got a legal obligation there to recognise at least 5 working days accrued and then taken annual leave. One point I did want to mention here, just in relation to build-up of annual leave. So as I said, we're seeing at the moment a lot of our clients have employees where there's a huge amount of annual leave that they've not taken over the course of the year. And what do companies do about that accrued annual leave if an employee is still not taking it, they're not voluntarily taking it? Well, under Article 29(2) of the AIFC Employment Law, companies are entitled to allocate mandatory periods of annual leave. So that's one of the most appropriate and most cost-effective ways of managing annual leave, that you can allocate a mandatory period of annual leave. So, for example, you could say to your team, to your employees, we know August is going to be quiet because it's still the summer. And so we're going to allocate you 10 days of annual leave that you need to take between the 10th and the 22nd of August. And so what that does, that's lawful as long as you give 7 days advance notice in writing of the annual leave. So it's perfectly lawful. It puts the employee on annual leave. It means it gets deducted from the total. So what you're not going to end up with is when we get to October and November, hopefully when the economy's all coming back and business is strong, you're not going to end up losing, 60, 70, 80% of your workforce because they need to push through their annual leave before the end of the year. So if you want to manage your annual leave, it's possible to do that under Article 29(2) of the AIFC Employment Law. I can see that a question has come in relation to what is the responsibility for the employer to provide an employment contract to an employee. That's a good question, and actually AIFC Employment Law deals with it really nicely. There's an obligation on the company to provide an employment contract. It says within 2 months of the start date of employment. It says that the employment contract should be in English, and there's a section within the AIFC Employment Law that sets out all of the different terms that need to be included within the employment contract. There's a lot, so it's worth looking at that. It's things like salary, of course, job title, name, start date, but there's quite a lot of terms that need to be included within it. Obviously, and this goes for all topics we're discussing today, if there's any follow-up questions or you need support with anything, please get in touch and let us know. And if you need support in relation to what needs to go into an employment contract, again, get in touch with us. Our contact details will be available and we'd be pleased to discuss it with you. But the obligation is on the company to provide that employment contract and make it in English. If somebody is not comfortable with English language or it's their second language, they don't understand it, then the AIFC Employment Law says that it's important for a company to explain those terms to the individual in their first language and make sure that they understand it. The obligation doesn't go any further than that. So it doesn't say you have to set out the employment contract in their first language. You don't need to do that. You just need to make sure they understand the terms of the employment contract. So sick leave, not going to spend too much time on sick leave, just so that you know it's set out in the employment law, up to 60 days sick leave per year. Again, this is an important term that needs to be included in the employment contract because sick pay amount to be paid is set out in accordance with the employment contract. So some companies will say the first 20 days are at full pay, the next 20 days are at half pay, the last 20 days are without pay. Some will be more generous, some will be less generous, but it's really important that you do set out something in your employment contract, because if you don't, then it's likely that all 60 days will be at full pay. And it also says companies may terminate for excessive sick leave. So that's described in the employment law to say if somebody takes more than the 60 days, they can be terminated immediately for excessive sick leave. Really important point to mention there, though, is that you have to balance that with disability discrimination. Michael will talk to you about disability discrimination shortly, but obviously if somebody's sick leave is because they've got an underlying disability, then could be an act of disability discrimination if you terminate them because of that without being able to justify it. Maternity leave, pretty straightforward. It's 65 working days maternity leave, first 33 days at full pay, the next 32 days at 50% pay. So that works out to 65 days in total, approximately 3 months of paid maternity leave. In the market, we know that a lot of clients will go provide a slightly longer period than that. So you could give those 3 months at statutory pay and then offer another 3 months of unpaid leave, or you could add on a bit of annual leave to that 3 month period. But yeah, generally in the market, we see clients offering a slight enhancement on that 65 working days. Really important that the law is very clear that you cannot terminate because of a period of maternity leave. You need to protect somebody's position whilst they're on maternity leave to come back to the organisation. End of service gratuity, you might be familiar with this. It's quite common, certainly within this region. Expats are entitled to gratuity. Nationals that you employ within the workforce are entitled to the pension rather than gratuity. And so it's really important, again, that the employment contract confirms that, because what you don't want is to employ somebody and offer them a pension and a gratuity inadvertently. So really important that you're familiar with that and that you clarify what somebody's entitled to. Equally for an expat as well, if you have a company pension scheme, you can offer that to the expat instead of gratuity, but again, needs to be confirmed in writing in the employment contract. The value of gratuity is 21 calendar days basic pay for the first 5 years, then it goes up to 30 calendar days basic pay for each year thereafter. which is quite a common formula that we see across the different jurisdictions. And then just finally on employment terminations. So there's really two types of employment terminations under the AIFC Employment Law. When it's the company dismissing, you can terminate with notice or you terminate without notice for gross misconduct. When you're terminating an employee with notice, it's important to know what the notice period is, and that should be set out in the employment contract. It cannot be less than the statutory minimum notice periods, which increase with length of service. That's what we recommend. So if somebody has been employed for less than 3 months, then the notice period is 1 week. If somebody's been employed between 3 months and 5 years, the notice period is 1 month. If somebody's been employed for more than 5 years, the notice period is 90 days or 3 months. So it's important that your employment contract reflects that. That's what it set out in the AIFC Employment Law. So that's when you're terminating with notice. When you terminate with somebody with notice, it's generally for a reason, well, it has to be for a reason that falls short of gross misconduct. So the type of reasons for which you may dismiss with notice are things like redundancy. Of course, we see a lot of redundancy dismissals at the moment. Poor performance would be another example. Perhaps misconduct, but minor misconduct that doesn't amount to gross misconduct, or maybe the expiry of a fixed term contract. Those are the types of reasons where you're going to dismiss with notice, with benefits, with end of service gratuity. The other type of termination is for a gross misconduct dismissal, where somebody's committed such a serious offence within your organisation that it amounts to a fundamental breach of contract. So I said earlier, an example might be somebody assaulting somebody within the workplace, could be somebody leaking confidential information of the company to a third party, stealing confidential information, or it could be some other form of criminal offence, like, for example, stealing and thieving from either the business or from a third party in their capacity as your employee. So those are some examples, but as I said earlier, really important that your employment contract talks about gross misconduct and sets out the types of offences that we as the company, in our sector, in our industry, with your particular policy and company ethics, see as gross misconduct. It's really important that those reasons go into the employment contract. And just the final point, just connected to termination, is Article 19. That's where the Article 19 is really important provision, which sets out that we are required to pay all final payments within 14 days of the termination date. So when you terminate somebody, it's really important that we pay all final payments, things like accrued annual leave, end of service gratuity, any other accrued benefits within 14 days of the termination date. If we don't, then that's going to be a breach of the Article 19 provisions. I saw a question on termination that I just wanted to come to before we move on. So the question was, a company dismissed an employee and is now denying that there was any labour relationship between the company and the employee. Okay, so in that situation, the employee would need to bring a claim and would need to somehow establish that relationship between the employee and the company. And that might be through email exchanges, it might be through job titles, it might be through social media, but they would just need to establish that relationship existed, and then the courts would accept that the employment relationship was there and would then interrogate the reason for dismissal, check whether that was fair, check whether all payments were made, and of course would also perhaps criticise and penalise the company if they didn't provide that employment contract within the 2-month period that they're required to do so. I know that there are some other questions that are being raised. I'm also conscious of the time, so I think we'll move on to the next slide now. We'll move over to Michael, who's going to take us through some discrimination. If we don't get to some of these questions now, we'll try to do it at the end of the session, and if not, we'll follow up by email afterwards. But now I'll hand over to Michael to take us through some of the discrimination provisions.
Thanks, Luke. Hi, everyone. So as Lucian's just looking now at some of the discrimination aspects of the AIFC Employment Law, which contain a Part 9. And this is one of the more complicated areas of employment law. So we're going to take a very high level look at it at the moment because you can, there is so much to it, certainly more than it is if you just read the law itself. You really can delve into detail, but we'll keep it fairly high level for the time being. So the very basic employees are entitled to not be discriminated against on the basis.
Michael?
Yeah.
If I could just jump in, it might not be with everyone else, but just on my line, it's just a little bit jumpy at the moment. Could I ask you to just maybe switch your camera off so that the Wi-Fi can just focus on the audio? Because I think it might just be that the Wi-Fi is struggling a little bit.
Yeah, let's try that. And if we're still having, Michael, it's David. If we still have some sound quality problems, maybe we'll just bounce it back over to Luke to finish out these slides. But let's give it a try with you off the camera, and let's see if that works. Okay.
Thanks, David.
Sure. Is that better?
Yeah, that sounds better. Thanks, Michael.
Good. Okay. So sorry, everyone. So I was saying, at the most basic level, employees are entitled to not be discriminated against on the basis of a protected characteristic that they have. And under employment law, there are 7 of these protected characteristics, which you see on the slide in front of you. Most of these should be fairly familiar to you. Running through them very quickly. The first one is you can't be discriminated against on the basis of your sex or gender. So you can't, for example, refuse to employ someone or treat them differently because they're a woman or indeed because they're a man. Marital status. For example, some employers we have seen employees to be married, but under employment law you can't discriminate on the basis of whether someone is married or not. Then we have race and nationality. So here talking with race is more about the employee's heritage, the culture, and often the colour of their skin. While nationality is more about the country they're a citizen of. So for example, you can treat someone differently because they are a citizen of a certain country. Then we have religion, which is fairly self-explanatory, and then age. Yeah. Now this is short against for being too old or too young. Yeah. Although it is important to note here that exception does apply, so that employers can discriminate against employees based on their age. And if that discrimination occurs because an employee has shorter service than another employee who is placed at advantage. So, for example, of this that we have seen, so just running through, so effectively you can't. For example,
Michael.
For example,
hey, Michael. I'm sorry. I think the line's still jumping a little bit. So I think what we'll have to do is I'll just finish this discrimination session at the moment, unless there's because I don't think there's any other solution that we could do with the technology.
Yeah, I think that's right.
Or indeed too young. If that discrimination occurs because, so for example, this that we have seen. Sorry, very happy to if it's still not working.
Yeah, no worries, Michael. Let me just take over for the rest of the session, and we can look at the technology afterwards. Okay. Great. So Michael was taking you through the protected characteristics there that are set out within the AIFC legislation. So these are protected characteristics that your workforce will have. So you'll have some employees within your organisation in the AIFC that will come from a particular country, or they may subscribe to a particular religion or be of a particular age, and they are protected from being discriminated against on the basis of that characteristic. And discrimination can arise in lots of different types of situations. So what we had set out in the slides were the different types of discrimination that employees are protected against suffering from under the AIFC legislation. So the easiest form is direct discrimination. So that's where a person is just treated less favourably then they would be treated in the same circumstances on the basis of their protected characteristic. So a typical situation that may arise with that is where you have an organisation. The organisation have lots of a particular type of nationality working within it, and then it has just one or two from another country. So, for example, in the UK, you might have a lot of UK nationals working within one company, and they just have one or two French people working within the organisation. And in that scenario, if all of the British employees are being paid a particular salary, but the French employees are being paid a lower salary, then that could be direct discrimination. It's likely to be direct discrimination because the reason that the French employees are being treated less favourably is on the grounds of their nationality. And where an employee can demonstrate direct discrimination, you cannot justify it as a company. It's important. You cannot justify it. The courts will find that it's discriminatory. The second type of discrimination that we wanted to talk about was indirect discrimination. So that's where a company applies a practice criterion or provision to a group of employees, and the impact of that PCP is that it has a less favourable impact on somebody because of a particular characteristic. So a classic example of that would be we need individuals to be promoted to a senior associate role. We need them to be 6 years post-qualification in whatever field it is that they're practicing. They need to have qualified 6 years ago. So a 20-year-old could say that policy that you have, that practice of promoting people with 6 years PQE, has an indirectly discriminatory impact on me because I'm 20 years old, and so it's impossible for me to achieve that, achieved that, and that's discriminatory against me on the grounds of my age, which is a protected characteristic. And prima facie, that's correct. It is discriminatory. But you'll see the third bullet point in the slide there is that there is possible to have an exemption where you can say either it's a genuine occupational requirement or it's a proportionate means of achieving a legitimate aim. And I think in that scenario, you could probably argue that both of them are justified. You could use both of those arguments, because you could say, for you to be a senior associate, for us to present you to clients and for you to operate at that level, it's a genuine occupational requirement that require you to have had 6 years experience. So that's one way you could justify it. The other way would be that you say it's a proportionate means of achieving a legitimate aim, and our legitimate aim is to have a proper pyramid of staff, of people working in the correct levels, of having a meritocracy, that people sort of work, get the experience, get the expertise, then get promoted. And those are our legitimate aims. And this is a proportionate way of doing it. And it may be, and it is discriminatory. It does have an indirect discriminatory impact on somebody who's 20. Of course it does, but it's justified. And so that's indirect discrimination. Another type of discrimination that we're seeing a lot of challenges around globally in relation to indirect is around things like equal pay across the genders. So women would often say, I'm doing the same role as a man, but I'm being paid a lower salary than a man. And they could very well argue that's direct discrimination and it's indirect discrimination. And that's something that companies really have to think about. Companies in the AIFC definitely have to think about in light of the discriminatory legislation provisions within it. So just think about whether, all types of benefits really, and it's about being mindful, and it's about having a policy. And you might recall when we were talking about policies earlier, I did include an equality policy, and it's important that you do have a policy within your organisation that's relevant to anti-discrimination provisions to give to give the managers and the HR team, a best practice approach to equality, and B, if you are subject to a claim, you can have reference to that policy to work out, how you complied with the policy, and then justify any such allegations. Final types of discrimination that we wanted to touch on: harassment, reasonable adjustments, and whistleblowing. So harassment is where somebody is harassed on the grounds of a protected characteristic. So that you can imagine what harassment looks like in practice. And we've seen cases under this type of legislation in the past. We saw one case where a female individual was harassed by her boss, who was male. and brought a claim under this legislation on the grounds of sexual harassment on the basis of her gender. So harassment is a very real claim that clients need to be alive to and aware of. And of course, as well as having financial impact, it can have a huge reputational impact as well. Reasonable adjustments, that's connected to disability discrimination. So if an employee has a disability and there's a practice criterion or provision that's applied that has a disadvantage in relation to them because of their disability, the company needs to consider what reasonable adjustments could be made to that PCP to enable the person to perform their role within the organisation effectively. So an example might be somebody, well, an easy example is somebody in a wheelchair can't access a building, so can't get into the office. What's a reasonable adjustment? Of course, it would be to create a ramp, to install a lift, to make their desk workable for somebody in a wheelchair. That's the type of adjustment for somebody with a physical disability. Somebody with a disability who is unable to attend the office, who needs to take more sick leave than a person without the disability, but then has an appraisal on the basis of, let's say, their financial performance, their billings, could say this should be prorated. This financial target should be prorated because my disability has an impact on me coming and working as much as somebody without my disability would have. So those are the types of reasonable adjustments you need to think about. Again, failure to make a reasonable adjustment is an act of discrimination in itself. So this is a proactive obligation on companies to proactively consider what adjustments should be applied to the workforce. Finally, just to really flag whistleblowing. Whistleblowing is protected under the AIFC law. I'm sure you're aware of that. And there's a right to not be subject to a detriment because somebody has made a protected act. So they've raised a formal complaint, a whistleblowing complaint. You can't then subject to them to a detriment. So, for example, dismiss them because they raised that act. That would be a breach of the employment law and the whistleblowing regulations. Okay, that's everything on discrimination. We've got 15 minutes left of the session, and I really don't want to overrun because I know you'll have commitments that you need to attend to after this session. But we did want to talk about COVID-19 generally and the impact it has on employment relationships as we begin to hopefully come out of the pandemic. I know that the infection numbers are still not where we would want them to be in Kazakhstan, but we do need to think about what the workforce will look like going forwards. So I wanted to I'm conscious we've done a lot of talking. I wanted to just have a couple of case studies during this part of the session for you to have a think about how things would play out within your organisation. So this is a cost-saving option. So obviously a lot of businesses are suffering at the moment. A lot of HR directors, GCs are being put into pressure to look at how they can save costs within the workforce. So you're the HR director for the business, head office in the AIFC. The CEO sends a message saying she wishes to cut costs in the business support team until the end of 2020. So, and that's in relation to personnel. So cutting employee costs. What options would you think of that you could implement to save some costs within your organisation? If you can just have a think about that, feel free to send some comments through on the chat and we can sort of pick them up and discuss them and discuss how you might go about implementing those in practice within your organisation. In the meantime, I'm just going to have a look to see if there's any questions that have come up that I need to address. But yeah, if you can just keep sending through any ideas. You may have already implemented some cost-saving measures within your organisation, so feel free to share those as well, because I think it's an important topic for people to be aware of what's happening in the market, what companies are doing, you know, what's permissible. There was a question in relation to annual leave that came in. Thank you for raising the question. And it was about carrying forward 5 days. And the question is, did I mention that in accordance with the agreement between the employer and employee, 5 days can be up to 20? Yes, I did say that. So 5 days is the minimum that an employee should be allowed to carry forward from 1 year into the next year, but it can be up to 20. So that would be at the discretion of the company, that they can agree with the employee that we will permit you to carry forward more than 5 days from one calendar year to the next year. And obviously this year is quite an exceptional year, so it may well be that employees will appreciate companies allowing them to carry it forward to next year, and also it will help companies manage their workforce over the next few months, when if we don't do that, there may well be a lack of capacity within the organisation as people are taking more leave to use up their leave before the end of the year. Another question in relation to discrimination, would it constitute discrimination on nationality if local employees are offered salary in the national currency of Tenge and foreign employees are offered their salary in USD? That wouldn't be discriminatory in itself if the levels of salary are the same. If the levels of salary are different, so you know, for the same role, one person's earning a certain amount, and for the same role, because they're a different nationality, they're earning a different amount, potentially that it could in itself be discriminatory. Of course, it's subject to public policy around any localization, any sort of private sector obligations in terms of recruitment and where the employees come from. But potentially in itself, if you're offered two different nationalities, a different level of salary, that could be discriminatory. As I said, if it's indirect discriminatory, it could be possible to justify that policy, but it's absolutely something you should be thinking about, definitely something you should be thinking about, and just making sure that any risk arising out of that is reduced. So just some comments that are coming in relation to the case study. For remote working, the payment can be 50% of the wage, depending on the amount of work to do. Yeah, look, I think that's fair, and we've certainly seen that. We've certainly seen that reductions in salary that are being implemented within all jurisdictions, and it is possible to do that. I mean, Article 20 of the AIFC Employment Law is quite strict in terms of reducing salary. It says that reductions to salary can only be implemented with the agreement of both parties. So what I would say, you know, and obviously salary reductions is an important way of managing cost over the next few months, whilst retaining headcount and not putting people out of work. So it is possible to implement, but we would always recommend that it's implemented with the consent of the employees. Because if you do it without the consent of the employees, there's a very real risk that the employees could bring a claim of unlawful deduction from wages, because it's just a unilateral change to a key term of employment. So do it with the consent of employees, go through a consultation process and to explain the rationale behind it. And obviously, I mean, we've helped so many clients around the world in relation to salary reductions over the last few months. And many of those clients have said to us, our workforce have never and would never voluntarily agree to a reduction in salary. And we've still managed to get it through. And we've managed to get 100% of people sign up to it. Because this current pandemic that we're going through is like none other that we've seen before. And all of those employees have friends, have family, have colleagues in different organisations that have been subject to similar cuts, and they're much more open to suffering from a short-term salary reduction in order to preserve their roles going forward. But really important that it's set out in writing and agreed. Of course, a really good way to incentivise staff to agree to the reduction in salary is to have a proportionate reduction in working hours. So if we're going to reduce your salary by 20%, we're going to reduce your working hours by 20% as well, to move everyone down to a 4-day week. Because that's the rationale, isn't it? That we're reducing salary because the economy is suffering. We're not getting as much business as we were this time last year. So if we're not getting as much business, then you don't need to do as much work. So it's a proportionate and equal reduction. So that's a really important measure. Thank you for raising that. Another suggestion around utility costs being decreased. Yeah, absolutely. You know, it'd be possible to reduce the costs, the office related costs. I mean, at the moment, so many people are working remotely and the office costs are being reduced. And I think definitely, you know, if you're talking to the CEO, that's something that could have a long-term impact in terms of the cost of the organisation, that you could reduce the office spend, reduce the office space, because, and we'll talk about the sort of workforce practices going forwards in a couple of slides, but certainly one thing we anticipate is that more people will be working remotely, even as we come out of COVID-19. And I think the other point that I wanted to make in relation to this case study was around end of service gratuity. So here's a slide that sets out some of the temporary measures that we're seeing implemented. But end of service gratuity is a really important point here, because end of service gratuity, which that benefit we touched upon earlier, is calculated based on your final basic salary at the point of termination. So if we're now asking employees to take a temporary pay reduction or even a permanent pay reduction, we need to consider that, because they will be thinking about that. They will be thinking about the impact on end of service gratuity, because of course, if today's the 14th of July, their salary is $10,000 per month today, and then on the 15th of July, it reduces to $5,000 per month. Immediately, the value of their gratuity is changed overnight, because if they left work tomorrow, their gratuity would be worth 1/3 of what it's worth today, from 15 down to 5. So what a lot of clients are doing when they're encouraging employees to agree temporary reduction in salary is to recognise the accrued value of gratuity and say, even if you leave employment late July, August, September, while your salary is lower, we will pay you in respect of your service up to the 14th of July at the value of $15,000 per month. In respect of gratuity, and that gives them a bit of comfort, and it also, although technically it's not set out under the employment regulations, technically it's the right thing to do, and it's certainly the market practice thing to do. So that's something to think about in relation to end of service gratuity. Potentially option to allow employees to work for third parties whilst they are on reduced working hours. A lot of employees will be asking that, so think about how that would work within your organisation. Of course, you don't want them working for competitors, so you may make that option subject to agreement on a case-by-case basis. Annual leave we talked quite a lot about, but as I said, you can apply that in a mandatory way. You can require employees to take their annual leave on certain dates. Think about travel policy. Think about it early, because if employees leave the country and they go back to a home country, or they go on holiday, or they go to visit family, and then they get locked out of the country or locked into another country, what's going to be the impact? Can they do their job remotely? Will you give them an enhanced annual leave to, whilst they can't get back in the country, or will it have to be on unpaid leave? But it's important that those policies are put in place very early, in the next week or two this summer, before people start traveling, so that they're absolutely clear what personal risk they're taking if they are traveling during this pandemic. Some permanent measures, so redeployment, we talked about secondments and transfers of employees outside the jurisdiction into other international offices. Permanent salary reduction, of course, is possible with the agreement of employees, and then a reduction to some of those benefits. I think somebody mentioned utility payments earlier, personal allowance payments as well, schooling allowances if they're paid. Those are the sorts of areas, additional benefits that clients are reducing now because of the pandemic. Where we do have to make a more permanent change, redundancies and restructures is something that a lot of clients are doing. I don't want to go into too much detail because there's no statutory redundancy procedure under the AIFC Employment Law, but what we will say is we recommend this type of policy that we set out in the slides. And we recommend it because it's easier for employees to accept if you go through a consultation procedure, but also, even though there's no statutory redundancy procedure, there's always a risk of a claim coming from a different angle. For example, a discrimination claim. So if you make somebody redundant, they may, genuinely suspect that it was connected to a protected characteristic. You might make a female redundant who believes it's sex discrimination. You might make somebody from Asia redundant who believes it's race discrimination. But if you've got a strong and solid redundancy procedure, then that will help to defend a claim of discrimination where you have made somebody redundant. I'll leave you to go through that process in your own time. But as I said earlier, do always feel free to raise any questions with us as you're going through the materials. So just a final case study to leave you with. So the new normal way of working from an HR perspective. So the CEO gets in touch again and asks you to prepare a report on the new normal way of working. So what do we see the workplace will look like as we come out of COVID-19? What will be the potential changes and recommendations that we should consider including within the report? Well, I'll just jump over to the next slide, which really sets out what we're seeing in practice, what we anticipate from horizon watching will be the new normal. And we read, I recently read this in a Forbes report as well, that really there were 3 distinct phases in relation to COVID-19. So there was a phase 1 when we were all suddenly in a reactive mode where we had to respond to the pandemic. People were working remotely temporarily, but on a 5-day per week basis, immediately in a way that we'd never seen before. And we were all responding to that and trying to make sure the business continued to tick over. People were still able to do their job. People were able to continue working. And that was just sort of sticking a plaster over the current arrangement and just keeping and surviving with the business. Then there's phase 2, which is not just surviving the pandemic, but thriving in the pandemic where possible. So clients are now looking at the working arrangements with people still working remotely a lot across the world and saying, well, what can we do with people working remotely to continue with our objectives, with our vision, continue to push our business forward? You know, how can we continue to engage and develop relationships with clients? How can we continue to upskill our staff? How can we continue to collaborate as an organization? So it's now clients using with technology, using the remote working as an opportunity to engage with their staff, engage with their community and clients to thrive. And this is phase 2. I feel like we're in phase 2 now, and particularly a lot of the clients we talk to. But then phase 3, where it gets really interesting, when we come out of COVID-19, we talk about redesigning the business, the new normal that we're all talking about. You know, what's that going to look like? And what was really interesting in the report I was reviewing was that one of the statistics said that by the end of 2021, so by the end of next year, 25 to 30% of staff, professional services staff, will be working from home on multiple days per week. Now, what I find really interesting about that statistic is that if you had told me that 6 months ago, I would have said that sounds interesting. That sounds like a very nice idea. But I can't see that applying to our organisation, our regional organisation. People aren't that way inclined over here. Maybe in the US, maybe in the UK, but not in Central Asia, not in the Middle East. However, I would say now that statistic looks pretty low to me. You know, I'm sure that there'll be 25 to 30% of our staff at Pinsent Masons in this region working from home on multiple days per week by the end of 2021. So there definitely is going to be a new way of working. And that's part of it. Another part of it is part-time working. So again, not as common within these types of jurisdictions, part-time working, not as common in the AIFC as in some of the European jurisdictions. But again, with salary reductions, with 80% of pay, 80% working hours, companies by necessity are having to put people onto part-time working hours. And what that does is it gives employees the experience of part-time. Some employees will like it, they'll want to continue with it, but also it gives the companies the experience of part-time work, and they can see the advantages of it. They can see that, you know, it gives them a more flexible and more dynamic workforce, and that maybe is more appropriate for the economy as we go forwards. So part-time working could definitely be something that we see more common in jurisdictions like the AIFC. And then of course the gig economy, which is all about alternative ways of working. It's about consultants, it's about self-employed contractors. You know, it is about people working part-time. So the gig economy is also going to, I think, be one of the big winners coming out of COVID-19. So those are some examples of the new normal, some things to think about. Final slide, I'm conscious we've just gone over the hour, so let me just quickly run through the takeaway points. So things we wanted to cover today, and again, you know, this isn't going to give you the complete set of employment law know-how to take to your organisation, but we want you to be mindful of some of the key things that create risk within your organisation for you to think about at the moment. Employment documentation, so offer letters and employment contracts we talked about. Think about your handbook and your policies, things around discrimination, leave entitlement we spent a lot of time talking about, and it's good to have a policy around annual leave and sick leave and maternity leave. Whistleblowing we touched upon. Consider training for managers, particularly around offers of employment and discrimination and performance management. Be aware of these discrimination laws that we spent a bit of time talking about, and of course COVID-19 and the new normal, what we just covered in the final chapter. I'm conscious there's a few questions that I haven't managed to come to and that we've just gone past the hour, but what I think would be the most appropriate next step would be for me to hand over to David. Thank you all for your time on the call today. I'll hand over to David now to see, David, if we've got time for questions, how you'd like to conclude the session.
Yeah, thanks so much, Luke. That was fabulous. Yeah, I think we have one question that came in from the audience. We have time for that, and then I'll make a couple of concluding remarks. Almas, do you have that question that came in?
Yeah, I have forwarded several questions to Luke, but I guess we have not enough time for them. We have one raised hand. Maybe we will ask to ask this question orally. So
Sure.
I'll try to unmute. Please, admin, try. So there is no response.
Okay, fair enough. If anybody has any questions after the fact, please feel free to email them to us, and we'll make sure that Luke and Michael get those questions, and we can respond by email going forward. I'd like to sincerely, on behalf of the Academy of Law, thank Luke Tapp and Michael Chattel for their absolutely fabulous overview of AIFC law and practice. And, you know, as a bit of a personal aside, I met Luke a couple years ago in the Middle East, and I was working for an organization that was running, among other things, probably the highest profile legal awards in the region, where the organization was recognizing excellence in the legal practice, both on an individual and on a law firm basis. And Luke Tapp was voted from among his peers of about 800 voters at a big event as the Young Lawyer of the Year. That was about 2 years ago, I think. He's still young, and I understand now why Luke was recognized by his own peers in the profession for his excellence. And I really mean that sincerely, that law has a couple of sides to it, especially if you're a consultant or a transactional lawyer, where you're giving sound legal advice. Of course, it's obviously very important for your company to be aware of labor and employment laws and regulations, and to understand how those provisions will be interpreted and applied, and how companies can make sure that they remain compliant through various mechanisms like employment contracts and so forth. So obviously that really matters, because you're talking about protecting the company from liability, making sure it does the right things in compliance with laws and regulations. But Luke's presentation also took it that next step further, which is, remember, at the end of the day, employment laws are very much a part of the day-to-day business of human resources practice and talent management generally. Now, this really matters. You know, Luke had a lot of very practical advice that he was giving about employment contracts and so forth. But also toward that last part about the new normal, Luke was acknowledging that, you know what, at the end of the day, It's about compliance with laws, but it's also about managing your workforce in a way that is humanistic, in a way that recognizes that people are really your company's best assets. It's not trite to say that, it's true. So the idea is to make sure that you're managing that workforce in a way that the workforce feels positive about their job, they feel positive about the corporate culture, that they know that human resource policies and practices are going to be fair, they're going to be consistent, they're going to treat people even-handedly. And guess what? That becomes part of the intangible corporate culture of the firm. And that's what enables companies to develop a positive reputation in the marketplace. They can develop an image and a reputation for being a top employer with a culture that is based on learning and is based on fairness and is based on commitment to its people. It also becomes a retention strategy. You know, when the labor force gets tight and top talent is in high demand, well, guess what? The best companies are those who are going to have a humanistic corporate culture, and they're going to be the ones who can both attract and retain their best talent. So I think that's really important to keep in mind as practitioners, and that's the human side. And, you know, there's kind of an easy rule of thumb without sounding trite or smarmy, but the idea is we all have been in management positions. As a lawyer, you're in an advisory position and so forth, but we all started somewhere. So it's important, I think, always to keep in mind, what does it feel like as an employee, you know, to deal with HR practices at the workplace? Always keep that in mind. So whether you yourself have been through any HR related issues, or you are just getting started or whatever, is the way the company conducts itself and treats its employees really do make an impact. So try and keep that empathy, you know, in mind as you deal with HR issues. So with that, Luke, Michael, we really very much appreciate your presentation today. It was fabulous. We're going to welcome you back. Be careful. We're going to welcome you back to this Academy of Law platform.
We'd love to.
We look forward to you being part of the AIFC family. So thank you very much. To all our guests, I just wanted to mention, I think we had about 75 people who registered or thereabouts. And normally when people register for events, maybe they show up and maybe they don't. But here we had at one point, I think about 58 people online, which goes to show that this is a relevant, interesting topic. And it goes to show that your own commitment to legal education during these difficult times. So thanks to everybody for your participation, and have a great day.
Thank you, David.
You're welcome. Bye-bye.
Bye-bye.